Okay, everyone, so excited to be here with you today. My name is Maya Simek. I'm the legal director at Equality Ohio, and I am very excited to be presenting our fabulous legal staff as they tell you a little bit about a whole bunch of things. But we wanted to start off with our overview with some messages from the wonderful sponsors that help to make this event happen. So I'm going to turn it over and give you all some video introductions from our sponsors.
So this is our sponsor, and so today this is being sponsored day 4 by the Law Office of Maritza S. Nelson.
Well, so what we'll do is we will move on and then we will bring you back with our sponsor at the end of the event so that everyone can end that way. But without further ado, I want to be able to get us going so that we are all able to hear the wonderful information that our legal clinic staff has for you. So all right, so today for your attention and time, we have 3 amazing legal clinic practitioners that are here to share a little bit about what they're working on and the state of affairs in the state of Ohio. So a little bit about us. I am the legal director. My name is Maya Simek. I'm excited to be here and represent Equality Ohio and get to work with these amazing people who are going to be talking to you a little bit about what they're doing. So we have Kate Mozynski, who is uses she and they pronouns, who is our Cleveland-based staff attorney and who is actually going to tell us a little bit about some of the cases, case types we have, and why trauma-informed lawyering is so important to us as an organization, as well as like some ways in which we've seen that happen throughout our work together. Then we have Emily Myers, who's she, her pronouns, and she is our Cincinnati-based staff attorney. And Emily is going to give us a little bit of an overview of some of the ways that legal changes or case laws have updated across Ohio and what impact they have on us and what we're doing. And our newest addition, which is Kim Akins, who uses she, her pronouns, and she is our fabulous staff attorney that is focusing on assisting people who are living with HIV and AIDS. And it is a cool new project, and she's going to tell us a little bit why HIV's laws need to be modernized and why they are disproportionately impacting people in the community. So for those who like visual representation, here is our outline. We will also end with questions and answers. We do ask that if you have any particular information that is sensitive or that is related to you personally, that you save it and ask us at a different time just for your sake of confidentiality. With that said, I'm going to turn it over to Emily.
All right. Thank you, Maya, for that introduction. And thank you all for being here today. I'm excited for this. I especially love my topic. I love to talk about the legal landscape. And I'm going to be talking about sort of what's happened over the last year. We've had, from a legal standpoint, a lot has happened. We've had a couple big Supreme Court cases have come down that affect our community, both last term, so last June, and also just this June. We had a big case come out last week that I'm going to talk about. What else has happened over the last year? Well, we had a change in the presidency, right, which has had some dramatic changes in sort of what's happening in some federal agencies, good changes, I will say. And I'm going to touch on those as well today in my 20 or 25 minutes. And then I will end with the other big thing that has come out in the state of Ohio. If you haven't heard, we are finally allowed to change our gender markers. If you have an Ohio birth certificate, folks can finally change your gender marker on your birth certificate. And we finally have guidance from the Ohio Department of Health, which is the agency that oversees that birth certificates and correcting them. And we finally have some guidance as to what that process is going to look like. So I will end my 20 or 25 minutes there. So without further ado, Maya, go ahead and okay, so I'm going to start with the big Supreme Court case that came out last June. In fact, we're about a year and a week out from the big Bostock decision. And if folks here in the audience have been or on EO's listserv or are sort of regulars in our group, you've probably heard Bostock. You probably even just heard it in the mainstream news. I mean, it was a very big court case that came out. And we are at the 1-year anniversary. So sort of where are we, right? So just as a reminder, what Bostock decided. Bostock decided, written by Neil Gorsuch, and I have sort of a snippet here on the slide, that the term sex in the federal statute, Title IX, the word sex includes sexual orientation and gender identity. And so the result of the case was to say that employers who have to comply with Title VII, was I saying Title IX? I meant Title VII. Title VII prohibits discrimination in employment on the basis of race, sex, religion, a bunch of other protected classes. But so because the term sex now is ruled to include gender identity and sexual orientation, employers who have to comply with Title VII can no longer discriminate on that basis. And so very, very big decision. And sort of when it first came out, I mean, if you're a lawyer, if you read the decision, I mean, just really great quotes written by a conservative justice. But of course, on the terms of the decision, it was really only focused on Title VII, right, which is a federal law, not a state law, and it's a law that is dealing with employment only. So everyone in the community, especially the lawyers, are like, well, how far can we take this, right? Like, can this be applied to Title IX? Can this be applied to the Fair Housing Act? Can it be applied outside of employment situations as well? Can we get it sort of applied on a state level or a municipal level where it would capture more employers? I said that only employers who have to comply with Title VII have to follow the Bostock decision, and the only employers who have to do that are those that employ 15 or more employees. So, a lot of small businesses don't actually have to comply with Title VII, and whereas they might have to comply, there's probably a state law, and in fact, in Ohio, we do have a state law that captures employers who employ 4 or more employees. So we would love for this Bostock reasoning to be applied to Ohio's equivalent of Title VII, right? So that more employers in Ohio have to comply. Okay, so again, that decision, the Bostock decision, came out last June. And then, Trump was still in office. We still were dealing with the Trump administration for about 7 months, right? We had the election in November. It took a bit of time to call that election, but then we had the lame duck session where, we had to wait for Biden to be inaugurated in this January 20th of 2021 to start seeing how Biden was going to how Biden and his administration were going to change things for our community, as they, committed to many times in their campaigning. So the very first thing they did, actually, on the day of the inauguration, they issued a general executive order. And it was kind of a general executive order that, to say that folks in our community, that we should not be facing discrimination based on sexual orientation and gender identity. But it was sort of just a general executive order. It called for all of the federal agencies to look at their policies and see where they might not be complying with such a directive, and to kind of do an audit, if you will, of their policies and see where they can update them. And that's where, if you've been kind of watching the news, legal news, but even just mainstream news, you may have seen in the last few months, there have been sort of these agencies that have come out with really good statements that, like, I have here on the slide in education, in April, the Department of Justice issued a guidance memo explaining that it would follow the Bostock reasoning in how it interprets Title IX. Title IX is the federal statute that prohibits discrimination on the basis of sex in educational opportunities. And that includes, K through 12 and higher education as well. So I just kind of put in this slide and the next slide a breakdown of like where we are and what agencies have come out with sort of those directives. We have in healthcare, Health and Human Services issued guidance back in May that it would be interpreting the ACA, also known as Obamacare. It's sort of non-discrimination language that prohibits discrimination on the basis of sex. It would be following the Bostock reasoning, which is great. And then actually just last week, the Department of Justice filed a statement of interest in a case in Arkansas's courts, where Arkansas recently passed a law banning gender-affirming care and medical care, and the Department of Justice is getting involved in that case, just saying, yeah, this stinks actually, and stop doing this. And not only stop doing this, but it's unlawful, as how we are interpreting the ACA. So here are just a few other areas where we've had federal agencies coming out saying they're going to apply the Bostock reasoning to their kind of area of expertise. HUD explained housing and urban development will be following the Bostock reasoning in terms of how it interprets the Fair Housing Act. Just over the weekend, I don't know if you caught this in the news, folks, but the Department Secretary of the Veterans Affairs, the VA, announced that they will start covering gender confirmation surgery for vets, which is tremendous and great. The only problem is the process for doing this will probably take a few years. And then we're going to have another presidential election, aren't we? But it was still a very great announcement to read over the weekend that the VA is committed to this as well. I will note, this is all coming from the executive branch, right? I mentioned this kind of started with the Biden inauguration and his executive order. For the non-lawyers in the crowd, executive orders are great. They are orders from the president, and they are under their presidential powers allows them to do this. But they can be revoked or they can expire like at the end of the presidency. So the next president can go ahead and revoke Biden's executive order and issue their own, which is why they're great during the term of the presidency. But the thing that's going to have a longer and lasting impact is passing laws through Congress, right? Which is why we are still, especially at Equality Ohio, this is our big thing, the push to get the Ohio Fairness Act passed. Because then we have a state law, right, that prohibits discrimination for Ohioans, and we wouldn't have to rely on the executive order and federal agencies interpreting things how we want, and that can be revoked with the next president. Same thing with why we advocate for the Equality Act to be passed, right? The Equality Act is the federal corollary to the Ohio Fairness Act that would prohibit discrimination on the federal level. So those are still very important because these executive orders have somewhat of a limited reach. And I want to be mindful of that. And that's why we still push for laws to be passed through Congress. They may take a little bit longer to get through, but they are harder to undo, right? With every change in the presidency. Okay, so the last thing, I'm watching my time. The last thing I'm going to talk about is, again, the recent changes to Ohio law that allows us now to change our gender markers on our Ohio birth certificates. So just a little bit of context here. Ohio was unfortunately one of two states in the entire country. It was us in Tennessee who didn't allow a person to change their gender marker on their birth certificate. The ACLU, along with I think Lambda Legal and Thompson Hine, the law firm, challenged this. They filed a lawsuit, I believe it was back in 2018. It was a long time ago, to challenge that policy. It took a while to get to a decision. I mean, it took 3 years, close to 3 years to finally get a decision from the federal district court, which is like the trial court level in the federal courts. The case was called Ray versus McLeod. And finally, at the end, the mid-December of 2020, so about 6 months ago, finally got a decision from the judge that said, yeah, this is wrong. This is unconstitutional. Ohio, you have to allow this based on equal protection grounds, that you're treating trans and non-binary folks differently than cisgender folks, and also on privacy grounds, that not allowing a person to change their gender marker on their birth certificate basically forces a person to out themselves every time they have to show maybe some identity documents, and if they don't all match, right? So it was a very good decision. We had a little bit more waiting around to do because I mentioned this decision came from the trial court level. Well, the other side, or either side, if any side is unhappy with a court decision, they always kind of have a chance to appeal, right? And there's a period of time where sort of in January, we were waiting to see if the state was going to appeal. Luckily, they did not. But that also meant we had a little bit more waiting around to do, because even if they didn't appeal, well, now we had to wait for the Ohio Department of Health, which again is the state agency that oversees correcting birth records. We had to wait for ODH to give us some guidance as to, okay, what is the process going to be for how a person changes their gender marker? And that guidance is what just came out at the end of May last month. Okay, so here's where I'm going to sort of get into what the process is going to look like, and I'm going to start with, it's not as clear as we would have hoped. So basically what ODH said was, okay, we will change your gender marker on your birth certificate if you give us a court order that directs us to, right? From like your local probate court. But then it kind of punted and said, well, but the probate court can decide their own process and like requirements for what it's going to require of folks to get that court order. And at least in Ohio has 88 probate courts. There's one per county. So that is 88 different courts that could have 88 different processes for what they're going to require to allow a person to change their gender marker. I will say, we will provide the legal clinic contact information at some point in this presentation. Please contact us. We, along with our partners at Trans Ohio and Octopus LLC and Equitas, we are all kind of doing the work right now. Equality Ohio, we have a team of interns kind of asking every single county court, okay, what's your process going to be? Have you published it? Like, is it available to the public on the website? If you don't have a process, like, what should we be filing? We are checking on all of that for you. So please give us a call, reach out to us. We are trying to keep track of what each of our 88 counties is doing. Okay, so that's sort of the broad guidance. It's guidance with an asterisk, right? But I'm going to give a little bit more information as to what it could involve. Okay, so first I mentioned it's going to involve a court order from a probate court. Unlike gender, unlike name changes, where if you're changing your legal name in Ohio, you have to file in the probate court where you live, and you have to have lived there. Well, I'll get to that in a moment. There's a change there, but you have to file in the probate court where you currently reside. For changing a gender marker, you have the possibility of three different probate courts where you could file. You could still file in the county probate court where you currently reside, or you could file in the county probate court where you were born, or you could file in the county probate court where your mom resided when she gave birth, at the time of your birth. So just as an example, I'm going to use the Dayton area as an example. If you are currently living in Greene County, let's say you live in Beaver Creek, okay, but you were born in the city of Dayton at Miami Valley Hospital. So you were born in Montgomery County. And at the time of your birth, your mom was living in Troy in Miami County. You would have three different options for what court you're going to file in. And that's just, that's a little bit of, that could be helpful, as again, I'm saying some of these courts, we don't know what guidance they're giving us, or how, what you have to do to get that court order. If you have the option of if you have three different courts you could file in, and in one of the courts has published guidance and we know what they're going to ask for, you might prefer to file in that court because you at least kind of know what the process is going to be. It might give you a little bit more comfort there. So you have options there. Of course, you might not have those options. You might be someone who you live in the county that your mom lives and that you were born in, and so you don't have really a different option than the one. But you might, and that's something to consider. And again, we at Equality Ohio, our legal clinic, we are happy to talk about those options, and again, sort of give guidance as to what the county probate courts are doing and what they're asking for. Other things that could be involved in the process, depending on what court you're in front of. The court could require a hearing, which is where you kind of go in person generally, but during COVID, we have been doing telephonic hearings. So it's probably similar to the name change process where you go in front of the judge and they're going to ask you questions before they give you the court order. It's not required by ODH, but your county court might require it. The other thing that isn't required, but a judge might ask for it, is a publication step. And this is where, again, similar to the name change process, where the fact that you are changing your gender marker has to be published in a newspaper of general circulation prior to a hearing, let's say, or just prior to the court issuing a court order. We at Equality Ohio think neither of these are necessary, especially the publication step. As you can imagine, requiring publication of the fact that someone is changing their gender marker is requiring them to out themselves publicly, which is awful and terrible and shouldn't be required as part of this process, especially in the age of all of our newspapers are online and like exist there forever, unless they get archived. It should not be, the fact that someone changed their gender marker should not be like a Googleable thing, right? That just remains forever and ever on the internet. So if we were to be asked and give any guidance to a court, we would strenuously object to a publication step. The last thing I'll say on this slide, and I am almost done, I'm watching my time. Once you get that court order through the court, whatever their process is going to be, the court themselves forwards it to ODH. You shouldn't have to do anything. That's this last bullet point where it says the court shall forthwith forward to the Department of Health. Shall means they have to. So the department will automatically send it to ODH. ODH will then automatically update your gender marker, and there will be no notification, like there'll be nothing visually on your birth certificate, the updated birth certificate, that says that something's been changed, which is great. Okay, just a few more things here. That notice requirement, that publication requirement. If the court that you're filing in, or that a person is filing in, requires publication, and I just went over why that's terrible. But if they do require it, you should have an option to request to waive that requirement in the same way that you can request to waive the requirement in the name change process. Also for our non-binary folks, in this guidance with an asterisk that ODH gave us, they did not affirmatively say that, we're going to do gender neutral, the X gender marker. And in fact, they didn't change their policy. Still, with babies being born today, there's no X option yet. They did say, though, that, they will do whatever the court orders them to do. So if you can persuade a court in your probate court that you're filing in, if you can persuade a judge to order an X gender marker, ODH will do it. They have to, because they're going to follow the court order. So that's something to keep in mind. If you're a trailblazer and you want to try it, persuade your judge to do it, ODH will follow it. And again, in our legal clinic, we'd be happy to talk about that. There are some implications that might come up in terms of if you can get an X on your birth certificate, but maybe your license still doesn't allow it. We can talk through all of those and what that's going to look like for you. But again, that might be a possibility. And then just the last bullet point here is if minors want to, folks under the age of 18, if they want to change their gender marker on their birth certificate, it's similar to the name change process. They're going to have to go through a parent or a guardian to get that done for them. Okay, my last thing. So that was all gender marker, right? Your gender marker on your birth certificate. We have, for a while in Ohio, been able to change our legal name, right? On your birth certificate, on whatever gender identity documents you have, but we've been able to go through the legal name change process for a while. That state law that governs legal name changes has just been updated. It will be effective in August of this year, August 17th, 2021. And the big changes we want to flag, and these are good changes. The first one is, so for minors, again, folks who are under 18, they now have perhaps an additional person or party who can file for a legal name change on their behalf. The new law will add legal custodians to the list of folks who can file on behalf of minors, which is great. And then the other big change to flag, and this is a really big one, where before in the old law, or the current law right now until August, a person has to be a resident of their county where they have to file for a full year to even like get in the door to see a judge, to go through the name change process. If a person has not lived in their county for a year, they'll just be rejected right at the bat. It's a threshold thing. And so the change in the law is they've reduced the year requirement to 60 days, which is great. I will say in the legal clinic, I mean, I have had folks call up wanting to do a legal name change. And one of the first things we ask is, okay, where are you living and how long have you lived there? And they say, oh, I just moved. I just moved 2 months ago. And we have to say, this stinks, but you're going to have to wait 10 months, to file. So we're thrilled that that residency requirement has been so reduced, and it's only a 60-day waiting period. So that's great. One last slide that just kind of sums up everything. Again, I know it can be, if you're not doing this work, it can be sort of to keep straight in your head, but gender marker changes are one thing, name changes are another. You might be someone or know someone who wants to do a gender marker change and a name change. And we've been thinking that through in the process and how to advise folks in our legal clinic. So at the end of the day, we are happy to take everyone's questions. We'll have a Q&A at the end of this, but also please call us up if you have any questions about any of this, because I know it's difficult to navigate. I will say it's difficult to navigate, and I'm a lawyer doing it. But the fact that it doesn't help when all 88 counties can potentially be doing something different. So please contact the clinic if you have any questions as you embark on this process, or a friend or family member does. All right, and I will take it away. Take it away, Kate.
Well, hi everybody. First off, thank you, Emily, for giving us all of that information. And so, yeah, I'm going to talk to everybody a little bit about what we call trauma-informed lawyering, and then just some of the work that we're doing at the clinic. So our legal clinic, we are statewide. We are free, and we provide direct legal representation to LGBTQ plus Ohioans. The reason there's an asterisk by the free is just because our clients are responsible for paying things like court filing fees, or if there's a cost to get documents or a cost to file something in court, clients are responsible for that, but they are not responsible for paying for the attorney services. So for example, if you want to file for custody, you have to pay for the filing fee for that custody petition in your court, but you don't have to pay me any funds for drafting that custody fee or representing you in court in that matter. And then we have an attorney in Cleveland, so that's me, and then Kim Burrows over in Columbus, and then Emily in Cincinnati, and Kim Akins over in Youngstown. And we always say that we're trying to basically make 71 into a rainbow highway and connect legal services to our community across the state. So one of the ways that we do this, and one of the ways that we provide representation is what we call stabilization law. And this is a Meyer coined term that we all really adapted into our legal clinic. So when I say stabilization law, what I mean is the way that we address clients is we identify what issues can we resolve with a legal remedy that can help that individual human stabilize in their lives. I always tell my clients, I want to represent you in a way that makes you not need me anymore. What will help you stabilize in your life? What barriers can we remove so that you feel stable? A lot of times I describe it as a snowball rolling down a hill. So a lot of times that's the lived experience of our clients. So for example, your car breaks down, so you can't get yourself to work, right? And then you've got to make that decision. I've got to pay for my car repair. Otherwise, I'm not going to be able to go to my job and I'm not going to earn money. But because I paid for my car repair, I couldn't pay my rent on time. And now I've got an eviction notice that's up on my apartment, and I'm afraid that I'm either going to lose my job and become jobless, or I'm going to lose my apartment and become homeless, right? And that's the kind of situation that we find a lot of our humans in. And on top of that, it gets even more complicated because all of our folks are queer identified. All of our folks are of the community. And that sometimes can complicate things because it's not just finding a new job or finding a new place. It's finding this place that's safe to live, where you can access housing as an openly LGBTQ person, or it's finding a supportive or affirming workplace, right? So it becomes even more complicated. So stabilization law, what we really are trying to do is stop that snowball. How can we stop the snowball that doesn't until everything is really, really difficult in that person's life. And a lot of times people don't self-identify their issues as being legal problems, but a lot of times there are legal remedies that exist for addressing some of these life problems. A lot of times life problems are really legal problems, but folks don't always self-identify that they are legal problems in nature. So I'm going to talk to you all a little bit about trauma-informed lawyering and what that is. So stabilization law is kind of our framework for how we assess a person's legal issues in like the broad scale of like, what can we do for this human? But trauma-informed lawyering is how we try to approach our representation with our individual clients. I'm going to give a brief trigger warning here. We're going to be talking about trauma, not in any specifics, and we are going to be talking about folks who have histories of victimization with sexual violence, but no graphic descriptions of anything. But I just wanted to make folks aware that we are going to be talking about some of those things in this section of the presentation. First thing to start off on is just what is trauma? We hear trauma and trauma-informed, really used pretty frequently, in social service organizations and then in our clinic as well. But I think it's really important to start out with, what is trauma? So trauma, a lot of people say, oh, trauma is the thing that happens after a bad thing happens in your life. But I really like this definition, which is that trauma is any type of distressing event or experience that has an ability on a person's ability to cope and to function. And one of the reasons that I really, really like that definition is because trauma manifests in lots and lots of different ways. It manifests in different ways for different people. And also what can be a distressing event also changes as well. I picked this little cartoon. It's actually an artist who does this full series of cartoons about trauma and how trauma impacts individuals. So yeah, trauma, any type of distressing event or experience that has an impact on a person's ability to cope and function. So that manifests in lots and lots and lots of different ways. Manifests differently for each individual person based on their own lived experiences. And it's also really important to remember that folks can experience individual trauma, which is this bad thing happened to me. And then folks can also experience what we call community trauma. And that's, I feel trauma because I am a member of this group that's been marginalized and treated unfairly by the society that I live in. So that can be, folks of color, Black and brown folks, might experience community trauma. And then LGBTQ folks as well might experience community and trauma because of that feeling of being within a system that was not made for us, within a system that was not designed to serve our needs. So I picked this little picture of the woolly mammoths because it says the trauma that you experienced whenever it was is not ancient history. And I think that's really, really important to remember because a lot of times when somebody comes to an attorney and says, I have a legal issue, they're not their best selves in that moment. They're not experiencing, nobody calls a lawyer when everything's going well in their lives as a general rule. And it's really important to us at our clinic that we understand that and we respect that. And the other thing that's really important to remember as well is sometimes when people have experienced trauma in their past and in their histories, dealing with a legal issue in the right now times has a way of poking that past trauma. So for example, if a client is facing eviction and they've experienced past trauma as a result of living with homelessness, that legal issue or eviction might cause them to have a different response to someone who had not experienced homelessness in the past. So trauma is complicated. So trauma manifest, like I said, in lots of different ways. So trauma means that you might love somebody who hurt you. It might mean that you might feel like a different person, feel unsure, unstable, cut people out of your life, not be great about responding to your attorney's emails because it's hard to respond to that email and you get that mental block and it creates so much anxiety to do that sort of thing. And trauma also can sometimes result in people forgetting parts of what happened. So one of the things that we think about a lot in our clinic is how can we help you tell your story? How can we help you tell your story in a way that is going to help you access the legal remedies that we need? Because the way that trauma works in our brain is not in a nice, concrete, sequential narrative. It's just not the way that trauma works. If you've experienced trauma, the way that your brain responds, well, some of it might go over here, some of it might go over there, some of it might go over here. And then someone says, okay, tell me what happened. And you have no idea where to start, right? So one of the things that we are really conscious about in our legal clinic is working with individuals and meeting them where they are. So understanding that, hey, this person might not have texted me back. I'm going to follow up with them as opposed to assuming that they don't care about their legal issue, that sort of thing. It can make a really, really big difference. So why am I talking about all of this trauma stuff? So I made this little chart here, and it kind of is to highlight the experience that many of the folks that we serve have. So we have systemic inequalities, right? Systems that are not designed to serve queer folks, systems that are not designed to meet the needs of individuals who are within our community. We also have legal barriers, just access to justice barriers, right? It's difficult for folks who are living without a certain level of income. It's difficult for folks who are, BIPOC identified or who are LGBTQ plus identified, sometimes to access the systems that are meant to help resolve some of their problems. And it can be really intimidating to go into court by yourself and say, hey, I need to do this thing, right? Whatever that thing may be. And then we also have medical health, mental health, and individual trauma. And all of those things come into play at the same time and have an impact on our community being able to access legal services that they might need. So that's kind of why we developed the Equality Ohio Legal Clinic. We wanted to have this background of understanding the systemic equality, the legal barriers, the trauma, how those things intersect to prevent our humans from accessing legal services. So we decided, well, you know what, we're going to engage in trauma-informed lawyering. And trauma-informed lawyering is the way that we're going to address the folks that are in that progress flag circle of having all of the things come together in a way that's preventing them from accessing legal services that they might need. So briefly, what does trauma-informed lawyering mean? It can sound really, really buzzwordy. And I think it's important to bring it out of sounding buzzwordy and into what that actually means when our legal clinic represents a client in a case. So I picked my my two favorite queer-coded icons here, Bert and Ernie, to hold up the letter R. So there are 4 R's that are the way that we approach trauma-informed lawyering in our clinic. R number 1 is to realize the widespread impact of trauma, to say, yeah, it's there, it impacts folks in lots of different ways. To recognize the signs and symptoms of trauma. So for example, if I don't get an immediate response from a client, my first thought is the client is not that the client doesn't care. My first thought is how can we become more accessible to this human so that they can access the services that they need. It's also really important to recognize as well the role of implicit bias and trauma triggers. So that means both for individuals who are providing representation, so us as attorneys, and then also the impact that might have on our clients as well. And then the most important and hardest thing is to respond by fully integrating what we know about trauma into how we handle our cases. I'm going to be cognizant of the time here, and I'm going to explain that in a forthcoming slide where we talk a little bit about some of the cases that we've had. But the other important thing is to resist re-traumatization. So like I said, nobody calls a lawyer when things are going well in their life. And also a lot of folks have really negative associations with some of the systems that are, supposed to serve us but don't. So for example, police interactions, going to make a police report, going into court, testifying, having to make a statement against somebody who did bad things to you. All of those things can actively re-traumatize folks. And oftentimes our legal system is not trauma conscious in the way that we present evidence or the way that our systems are set up. So one of the things that we do as attorneys is we actively think about how can we creatively lawyer to resist the chances that somebody is going to face additional trauma as they navigate the legal system. So a little bit of trauma-informed layering in action. These were a couple of our clients. So it's kind of the way that we applied like those 4 R's of trauma-informed layering. So client letter A. Client letter A is an 18-year-old trans man, is an absolute sweetheart, and had been the survivor of really, really, really severe sexual violence when they were a kid. And they had been waiting on their name change for years because the thing that they associated with going to court was testifying against the person who had abused them. And it created a huge barrier for them and their ability to access a name change. And for any folks who are legal practitioners here, a name change, especially in larger cities, they're generally fairly straightforward hearings, generally pretty easy hearing. But in this case, this client was having such a hard time with the idea of going to court that it created a unique barrier for them in being able to access their legal name change and to feel like they could live as their authentic self. So we creatively lawyered in the situation. So I met this client and I said, hey, you know what? We're going to walk to court together and we're just going to file this name change in person. And then we're just going to walk around the court for a while. We're going to walk around the court. We're going to walk by the rooms where the name change hearings happen. And I'm going to do everything that I can to make sure that you understand every single step in this process so that there aren't any surprises. We also are going to talk to once we have a judge or a magistrate assigned, we're going to talk to the judge or magistrate ahead of time and say, hey, you're really nervous about this, and it would be really, really helpful for you to have a support person with you. So that's what we did. We brought a support person. We filed in person. My client actually sat with their support person and with the judge's permission, held the support person's hand during the name change hearing. And they had a little fidget thing for anxiety as well that we had talked about ahead of time. And those are things that a lot of times in legal representation, folks just wouldn't think of from an attorney perspective, but it makes a really, really big difference in the lived experiences of our clients. So in this case, client had a successful name change. They've now updated all their identity documents and they're able to live as their authentic selves with their correct name, which is awesome. So client B, another of my clients, this client had survived a sexual assault and they were looking for a civil protection order, which is a restraining order. It's an order that's a court order that says that that person has to stay away from you. So with protection orders, they involve providing testimony in front of a judge. And that was very, very, very difficult for this client. So we were able to provide them representation and successfully get that protection order. But we also were able to work with the client a step further, and we were able to get the individual who assaulted them's probation revoked as well. So now this client knows that this person is no longer able to harm them. So our client was able to get their legal name corrected, and we were also able to get the publication requirement for that legal name change waived, so that they are now living with the legal protection from the protection order with a new name in a new place, and a new place that they're living. They were assaulted in their home. And one of the things that we worked on was reducing some of the triggers that they were experiencing in their life by advocating with their landlord to allow them to move to a new residence, because it both felt safer and got them away from some of that trauma triggering stuff that had happened as a result of the assault that had occurred there. So that's kind of, I bring up these two examples because it kind of shows, in my opinion, the way that we address our humans holistically. So someone might approach with this saying, you know what, I want a restraining order. But once we find out more about what that person's needs actually are, in terms of like the legal name change, in terms of testifying at a parole revocation hearing, in terms of moving to a new residence so that they're no longer in that like trauma-infused space. These are all things that our legal clinic assisted with, because we were able to come up with an action plan based around this individual person's trauma to try and reduce the triggers in their life and help them get to a more stable place. So that's great. But what do we do? What services do we actually provide at our legal clinic? Where are we providing direct services? So I'm going to briefly cover those. And I think that there was a question in the chat earlier. I will hopefully answer that in a little bit more detail here. So these are the areas of law that we currently represent and to provide direct legal services. I say these are direct legal service areas because if we are not able to provide an individual services directly from our clinic, we do maintain a referral list. So if we can't serve someone, I always tell like clients, it's my goal that if I have to send you somewhere else, I'm going to try and send you to an attorney that I know will not misgender you. So culturally humble counsel. That being said, the things that we are able to do in-house. So we do criminal justice support and advocacy within our legal clinic. We don't actually provide criminal defense attorneys, but a lot of people don't realize that here in Ohio, if you've been the victim of a crime, you do have the right to an attorney to represent your interest as the victim. And that means doing things like supporting you if you need to go to court to testify, helping you with preparing a victim impact statement if that's something that you want to put on the record as well. And then also submitting briefing on your behalf if there's something that's impacting your privacy or your life as a result of the ongoing criminal case. We help with civil protection orders. And then we say law enforcement support interaction, which is a really, really fancy way of saying, if you're afraid to go and contact law enforcement because of your identity or who you are or any other reason, we will help you make those police reports, and we will go to a police station with you and we will help you. We do family law. Fairly self-explanatory there. Custody, divorce cases. We get a lot of those in Northeast Ohio, actually. We do tenant defense, helping folks if they're facing eviction. We do consumer law, so that's identity theft reporting and remedy, consumer debt negotiation, and creditor fraud reporting. A lot of people do not realize how important their credit reports actually are to helping ensure their legal stability. So we will teach you how to pull your credit reports. I like to call it preventative lawyering. We want to stop a problem before it starts. So we will help you with those things. We also help with benefit support. So that includes health insurance denials, including when folks get health insurance denials for gender affirming care. It happens fairly frequently that an insurance company might deny someone's transition-related care, deny coverage of like HRT, deny gender-affirming surgeries. We handle those cases. We also help folks access benefits. So things like food stamps, Social Security, disability income as well. We help with some of those cases. And then we also help provide administrative agency support. So that's unemployment compensation. And then also if someone has experienced discrimination as a result of their LGBTQ plus identity, if they've experienced discrimination in the employment context, we can file with the EEOC. And then if someone has experienced other forms of discrimination, we can file with the Ohio Civil Rights Commission as well, and we can help with filing there. And that's a necessary step if somebody does want to pursue a lawsuit in the future. The first step is to file those administrative agency complaints. We also assist with expungements and record sealing of old criminal convictions. And then finally, we represent folks in legal name changes and gender marker corrections. So that can range everything from brief advice all the way up to if someone doesn't feel comfortable representing themselves in court for a name change, we will take those cases as well, and we'll go to court with you. So that's kind of the landscape of all the areas of law that we practice. And then there are a couple of ways to get in touch with us. So you can give us a phone call, and you can also do an intake on the website. We have multiple ways of contacting us because we want to make sure that we're accessible to the folks that we're serving. So if you're more comfortable on the phone, somehow 1-855 LGBT law was not taken. Don't know how that happened, but we took it. So you can give us a call there. Or you can go to equalityohio.org/intake, and you can complete an intake form right there on our website and tell us a little bit about what's going on. So either way that you contact us, they're both equally fast, but our intake staff will reach out to you for an intake appointment, and then we'll be able to determine if we're able to provide assistance. And if so, staff attorney will reach out to you. And if not, we'll see where we can send you so that you can find additional resources.
What I want to do is kind of a really brief guided visualization. I want you audience members to imagine that this is your house and that you're living there comfortably, minding your business, going on about your day. Might not be the house you would choose, but for this exercise, let's just go with this one. Now imagine that somebody comes along and places a spotlight on your house. And every so often that spotlight flashes the words, "A bad person lives here." I'm thinking you might not be real happy about that. You feel targeted. People talk about you. People drive past your house. And depending on whether people believe what this light says, they may begin to harass you and issue threats. Now, you don't have to imagine this happening because it indeed happened here in Ohio. This happened because the police and the news media decided to target someone. The Dayton Police Department and the Dayton Daily News decided to point a spotlight at the home of Jason Davis because of issues that arose there. And part of the issue, and the reason we believe they did it, is because he is a person living with HIV. If you don't know, I'm going to do a real quick course in Criminal Law 101. Ohio has 6 criminal statutes dealing with HIV. These statutes enhance the penalties for persons living with HIV. And what's disturbing about this is these same actions that I'm going to describe to you, if committed by a person who does not have HIV, are misdemeanors. Real quick update. Misdemeanors are crimes that are able to be penalized by up to 1 year, but most likely only 6 months. Felonies go from 1 year to life, and in a capital case, the death penalty. So people living with HIV can be charged with the same crime as someone who does not have it and face significant prison time for that same behavior. Now, quickly, felonious assault, the fastest way to describe felonious assault is that you act to perform a grievous physical harm to someone. If you shoot someone, that's felonious assault. Solicitation, that you attempt to attract people for purposes of committing prostitution. Loitering for purposes to engage in solicitation, so you hang out and solicit people for purposes. Prostitution itself. Harassment by an inmate. Now, this one doesn't sound like it belongs in this, but indeed what it does is that if you are currently incarcerated, if you were to throw bodily fluids, you would be charged under this statute on this belief that somehow you could transmit HIV by doing that. And then last but not least, selling or donating contaminated blood. If you knowingly go into a blood donation center to try and do this, and you do not inform them, then you can be charged. Now, these are all felonies. These are not minor crimes. And specifically, I want to talk about the felonious assault a little bit, because the felonious assault is a felony 1, which is the highest tier rank of crimes in the state of Ohio. You can get up to 25 years or life under that statute. Now, as it relates to people living with HIV, it is that you failed to disclose that you were HIV positive before engaging in a sexual act. I'll get to why that's just a little crazy here, but that's what that statute does. It does not, unlike if you were charged under it ordinarily, it does not require you to cause grievous bodily harm. It does not require you to make the attempt to cause grievous bodily harm. It is just that you failed to mention before you engaged in a sex act that you were HIV positive. All right. This chart comes from the CDC. National penalties can run from under 1 year, from 1 to 5 years, 6 to 10, and up to life imprisonment. This is not a small thing, but these things are only directed at people living with HIV. What these laws do is they hyper-criminalize people living with HIV. More than just prosecution, it makes them subject to punishment that others are not. In Ohio, a person can go to prison for 8 years for failing to disclose their status before engaging. And they do not have to intend. It could be that you simply forgot. I'm not sure about you, but in the heat of the moment, sometimes you forget to say things. If you forget to say this, Ohio can send you to jail. Not jail, prison. Even though no harm results, if you do not transmit HIV in the course of this encounter, you are still subject to this. Now, the whole purpose of these laws, allegedly, which were passed in 1996 at the height of the AIDS epidemic, was to hinder transmission, to help people remember that HIV should not be passed along. The problem is that was 1996. We are now in 2021 and things have changed. And just along the way, you need to know that that particular statute, if you're charged under it and you're penalized for it, you can go to jail for longer than if you actually killed someone. I have had clients that have committed manslaughter that have done significantly less time than you would do under this statute if you were charged. All right, the Ohio Health Modernization Movement is here to try and end this discriminatory criminal policy. We want to replace the stigma and have the state look at the idea of treatment, as they've done with many drug crimes, and to change this statute so that it requires some things that are required in other criminal prosecutions. Our laws are outdated, overly broad, and they are disproportionately enforced to disadvantaged populations. The Ohio Legal Clinic and OHMM are currently collecting data on where these charges are filed, who they're charged, who they're filed against, and the results of those prosecutions. And as with many prosecutions, we're finding that they're directed at lower income people. They're directed at sex workers, and they're specifically directed at members of the LGBT community. At the risk of bringing up a topical issue, the idea of critical race theory is based in the idea that you want to look at how laws have a disparate impact against certain populations. These laws are exactly what critical race theory were designed to examine. I had to, when I started working on this, I had to update my slide. My information was faulty. There were 5 states since 2014 which had updated their laws and made the changes that we're proposing in the state. Since May, both Virginia and Illinois updated their laws. So there are now 7 states which have updated their laws. And I personally find it offensive that Ohio is behind North Carolina in updating their laws about this particular issue. All right, the changes that we're hoping to impose have to do with intent. As it stands right now, the failure to disclose does not require you to have an intent. All criminal acts have a level of intent that sort of define how severe that particular crime is. Felonious assault on its own requires you to act knowingly. If I pull a gun on you and I shoot you and I know that there are bullets in the gun and I intend to shoot you, I have acted knowingly. Under the failure to disclose portion, I don't have to have any intent. I just have to fail to disclose. I don't have to cause any harm. I just failed to mention when this happened. We are actually seeking to add the idea that in order to be charged under that part of the statute, that there be actual HIV transmission. As it stands right now, to use the analogy about shooting someone, it's as though I took a gun, I empty out all the bullets, you see me empty out all of the bullets, and I point the gun at you and say, I'm going to shoot you. Now, we both know that that is not possible. It's not going to happen. The Ohio statute, as it stands right now, there doesn't have to be a transmission. There should be some logic to the application of this statute to people in criminal behavior. We want to add defenses that say that if you are on viral suppression medications, that if your viral load is so low that you cannot transmit it, that would be a defense. The language that we use here is U equals U. Undetectable viral load equals, equals unavailability of transmission. So it's U versus U. U equals U. If you can't transmit it, then the reason for the statute does not exist because we've not caused a harm, a physical harm. If your partner, if the person is on PrEP, if the person uses a condom, and certain sexual, thank you, James, undetectable equals untransmissible. My brain just went out for a second. If you use condoms, and if you engage in sexual activity which has a negligible possibility of transmission, those should all be defenses, and that's what we're asking for. How can you help us? Well, what you can do is you can write letters to the editor. You can write letters to the editor, you can blog, you can contact us, we can give you information. And at the time that we're prepared to actually go forward with the introduction of the legislation, which will change all of this, you can contact us, get your talking points, and talk to your legislators at that time. Next slide. Real quickly, here are some talking points. Ohio's laws punish behavior that poses no or negligible risk, such as spitting, sex with a condom, or while on effective treatment. We now know, unlike 20, 30 years ago, that spitting on someone will not transmit HIV. But these laws were written back in the dark ages, and so we need to get into the new century. At the time in 1996, we assumed that an HIV diagnosis was a death penalty. In fact, as it stands right now, it is a manageable medical condition. People live full and healthy lives with HIV. And last, because we can, legislators like to hear numbers. It's a very expensive process to incarcerate someone for these particular crimes. It costs $25,000 a year, and that is a low estimate, to incarcerate someone. That money would be better spent pursuing treatment and supporting the 20,000 people who live in Ohio that currently have HIV. Now, to get back to this issue of the House. The police set up a sting for Mr. Davis in Dayton. Mr. Davis Well, he had an interesting way of making new friends. He listed an ad in the back page of Craigslist saying he would provide certain services to all comers, basically. Ooh, that's a bad phrase. So you would go to his house and he would service you. No money was exchanged. This was not prostitution. There was no pandering. No one else was doing it. It was just him providing oral services to the people who showed up. The Dayton police set up a sting, sent in an undercover officer who asked Mr. Davis, would he do this? And Mr. Davis said yes. Now, nothing happened. Nothing happened between the time he asked and Mr. Davis said yes. The officer went back out to his car, said, I need to go out and get something, went out to his car, brought the squad in, and they arrested Mr. Davis and charged him with felonious assault for failing to disclose that he was HIV positive. Now, this statute's vague. We don't know when you have to disclose. We don't know what the timing is on this. Would he have disclosed if they had started? Maybe. So we don't know how much time you have before you say you're going to have sex that you have to tell someone. So not only did they arrest Mr. Davis for this, after they arrested him, the Dayton Daily News ran his mugshot. Now, that's not unusual in criminal cases. What is unusual is that the Dayton Daily News ran a picture of Mr. Davis's house and his address on the front page of the paper. And I think you can guess what the result was from that. Mr. Davis has been harassed. Mr. Davis has been humiliated. Mr. Davis has received death threats. And oh, by the way, this is not the picture of the house. I was not going to do that to him. Now, all of this in the last year becomes crystallized that this is designed to stigmatize others. I'd like you to think about the last 15 months. In the last 15 months, we had an epidemic. People caught COVID, and over 600,000 people in the United States died from COVID. At no point during this epidemic were there any criminal prosecutions against people who may have transmitted COVID either intentionally or unintentionally. And the lethality rate is much higher and much swifter than the transmission of HIV. But you have never heard a word about anyone transmitting COVID from one person to another, to a family member, or intentionally doing it. And I don't doubt that there are people that don't believe in the science that would. And just to put a fine point on it, yesterday there was an article about Secret Service agents in DC. Over 900 Secret Service agents contracted COVID. Now, only a small group of those were assigned to the White House or assigned to presidential protection groups. But we know that the White House discouraged the use of masks, and COVID ran all through the White House if you weren't following that. Discouraged the use of masks, and the former guy, the former resident of the White House, mocked people that wore masks. But not only did he do that, when he caught COVID and he knew he had it, and he went to Walter Reed and was treated, during the time of his treatment, while he was still infectious, he insisted that the Secret Service drive him around to wave at people who were outside the hospital. Now, he was fully infectious, unmasked, and in a car with multiple agents. He knew. He knew there were things that people could do to protect themselves, and he forbade them from doing it. If that doesn't rise to a level of criminality, then neither should this failure to disclose law. So what we're asking from you is we're asking you to support us in our movement to change the law, to bring Ohio into the 21st century, and to stop the stigmatization of people living with HIV. Thank you.